Now I'm going to turn it over to Morgan Chandler. Morgan is with Hammerberg Lawyers, and Morgan will introduce her team and then pass it over to Nicola, who will be kicking off the presentation.
Thank you, Shelley. And thank you to everybody who's making time today out of your busy schedule to come and listen to this presentation. It is, as Shelley mentioned, very timely. This seems to be a time when people have the time to reflect and think about all of those things that have been on their to-do list, of which making a will is often left behind on the priority list. But we're here to provide a little bit of education, a little bit of background, and answer your questions, whatever those may be. So let me introduce myself. I'm one of the partners with Hammerberg Lawyers. I am not a solicitor, which means I don't draft wills. I am a litigator, so I'm the person that you turn to if when things go wrong after someone has passed. Among the Hammerberg Lawyers that we have here today, we also have Krista Simon, one of my partners, who is also a litigator, and Anthony Eden, one of our associates, also a litigator. And then of course we have Nicola Collins, who is our senior associate. She is a solicitor, so she is the person that you call when you need a will drafted or when you need some estate planning done. So I will hand it over to Nicola to talk to us about estate planning and making a will.
Yeah, so as Morgan said, I am a solicitor, which means that I do a lot of drafting documents, and a lot of estate planning is a part of my practice. So a will is something that we do prepare a lot for our clients, and getting those in place can be really, really important, as you'll see moving forward. So a will, essentially, it deals with all of the assets that you own in your personal capacity at the time that you pass away. So if you, for example, you have a corporation is separate to you. So that's not necessarily something that it will continue when you don't, but your will is something that deals with everything that is in your name. So those would be things like bank accounts that are in your name, vehicles that are in your name. If you own shares of a corporation, they're in your name. If you have real estate, those are in your name. So that's really what a will deals with. It also can appoint guardians for your children. So if you have minor children and you pass away without a will, and then it can complicate things if you don't have direction as to what is going to happen to those children. And so a will gives some certainty to everybody as to what your wishes are and who you want to take care of them if something was to happen to you. And so that's really the basics of a will there. So if you don't have one, what happens? If you don't have a will, then you die what's known intestate. And that means that the legislation dictates how your estate's going to be distributed. And the law says that your next of kin will inherit, and they up to a certain percentage. So if you're in a nuclear family with, say, 2 spouses and children, then the spouse will get a certain percentage of the first portion of your estate. So essentially, if you do die intestate, then the legislation dictates what you get and what your family will receive. And if you're in a spousal relationship, then your spouse will receive a certain portion of your assets, and then the remainder is split 50-50 between spouse and children if there's children. So that may not always be the way in which what you want to happen. So it's something to consider if you don't have a will, that there is some additional stress there. And that could mean that your spouse is left, dividing up property that you had between them and minor children, for example. It can add additional cost in going to the court and getting a grant of administration. And it does take some additional time to get the estate sorted. And obviously it can be stressful on those that are left behind. Let me see here. Sorry, I've got. So these are the types of things that you should consider when you are preparing your will. First of all, you want to look at what assets you have and how they're owned. Do you own property, for example, in joint tenancy? So joint tenancy is a legal term, and it means that if one of you was to pass away, if you own property with another person, the other receives it by way of survivorship. So it's quite common for husbands and wives or spouses to have real estate, to have the family home held with both names on title as joint tenants. And usually if that's the case, if one person passes away before the other will inherit it outside of the will by way of joint tenancy, by way of surviving the other person. Other assets to look at is if there's registered accounts. So if there's RSPs, tax-free savings accounts, if those have designated beneficiaries on those accounts, then they will also fall outside of the estate and therefore not go through the will necessarily. Other things are insurance policies. So if there's a life insurance policy with a beneficiary on that policy, then that will also be something where that beneficiary will receive that. That won't necessarily go through, it won't go through the will. So when I'm sitting down with the client and we're doing an initial consultation, we go through all the assets and the ownership of those assets and determine if this was to happen, is this gonna go through your will? But if that was to happen and all those beneficiaries that you designated weren't there, then it's possible that these will come back and go through your estate. So we look at different scenarios and see if the ultimate estate plan is achieving what the client wants it to achieve. And also, obviously, you know, if you give away your assets before you die, then they don't go through your will because you've already given them away. And you need to consider any debt that you have and how that will be paid on your death. Some other important considerations when you're thinking about making a will is who is going to be your executor and your trustee. It should be somebody that you really trust. A lot of people appoint close family members or close family friends to be their executor or their trustee. But there is also other options out there. There's professionals that do take on these roles and do this as a professional and do this as a profession. You also need to consider the residency of the trustee. So if the trustee is not located in British Columbia, for example, it could be really difficult for them to come and manage your estate. It could be difficult for them to secure your assets after you die and administer things if they're not here, but also for tax implications. If the trustee is not resident, and if you do have a trust in your will and the trustee is resident in another country, then the trust could be determined to be resident in that country, which may not be beneficial for the estate. So we always say, you know, try and pick someone that's local, that's trustworthy, that has some sort of experience in administration. You want to make sure that they're not, that they're of a reasonable age, that they're not your 95-year-old great-grandfather who may not, who you may outlive. So you're going to have to update your will. And you want to make sure also, if you do have a trust within your will, that they have a good relationship with your beneficiaries, because there may be a long period of time in which, for example, if you have a minor children, until those children reach an age where they are old enough to inherit part of your estate, they may be dealing a lot with your trustee in terms of asking for money and things like that and support during their lifetime. And you want to make sure that they're going to have a good relationship with that person. And this is obviously something for families with children who are minors. So minors in BC is anyone under the age of 19. You want to make sure that there is provisions in there for who is going to look after your children. You need to consider things like, are they financially capable of looking after your children if they needed to? Do they have a good relationship? Where do they live? Are they nearby? Are your children going to have to move to them, or are they going to have to move to where your children are? Does your guardian have a good relationship with the executor? Because the guardian may need to go to the executor to request money and from time to time to help with the upbringing of the children. Are they a similar age to you, or are they a little bit older, a little bit younger? Are they going to, like, you want someone who is going to be around when and if you pass away to look after your children? And also, I would always suggest to my clients having at least a couple of alternates in the will, because if you never know what people's situation is. If an event was to happen and somebody needed to step in to look after your children, you want to make sure that there is a backup if they're not able to do it at that time. And obviously having conversations with people before that time is really important as well. So this gets to the nuts and bolts of the will, what people think about when they're coming in. They say, who gets what? Who's going to inherit what of my assets? And this is really important to people because some people do spend a lot of time thinking about this. Something that you can do is you can list specific items in the will. So this ring goes to this person, this goes to that person. Or you could be a little more generic and just have everything fall into the residue and leave it up to your executor to decide how everything is distributed. If you do have minors, so anyone under the age of 19, you're going to need a trust within the will. And the reason why that is that if you passed away before your children reach the age of majority, before they reach 19, then the public guardian trustee would need to step in and manage their inheritance unless there's a specific provision for them in the document. You want to consider if you want to allow your trustee the ability to make charitable bequests. And one thing that comes up a lot is using specific amounts of bequests, so saying $10,000 to Joe and $10,000 to Mary, or if you want to use a percentage. And most of my clients, when we hash this out and speak through it, usually err on the side of using percentages, simply because your assets and your estate, they fluctuate during your lifetime. And for most people, their aim is to use up all their assets when they die so that they can enjoy themselves. And there may not be those specific amounts in the estate, or those amounts may not be appropriate at that time. So percentage is usually a good compromise there. So what does a trustee do? And you'll notice I've been using the term executor trustee interchangeably. So the executor of your estate is usually described as an executor, and they're the trustee of your will. So they take all of your assets at the time you pass away into your estate as trustee, and then they distribute them and they deal with them in accordance with the terms of the will. So what powers do you give them in the will? And usually we draft our wills so that the trustee has quite a lot of flexibility, and so they can do what they need to do at the time that's required to manage your estate. And those may be things such as being able to sell your real estate, potentially being able to mortgage your real estate if the trustee decided that, you know, in the current real estate climate at the time, maybe getting a mortgage on behalf of the estate and renovating the property would get the beneficiaries ultimately a larger share. And also your funeral wishes can be included in the will as well, because it's interesting, once you pass away, your body is actually property. So your trustee takes control of your property. Yeah, so there's a question here saying, does a guardian have to sign anything, agreeing? No, they don't, not in your will. Your will is a document that is yours, it's private, and you don't have to show it to anyone. But in saying that, it's always a good idea to have a discussion with them, because you don't, and I always advise clients to have the discussion, to ask your guardian, and to so that they know if you were to pass away and they are the last man standing, that you really want them to be able to be in a position to go and pick up your kids at that time and to take care of them. Now, in saying that, the will is used as proof of your intention, and there may be additional steps after you pass away, but they don't need to sign anything at the time. At the time the will is executed. And are there guidelines so people know what to include in terms of powers for trustees? Well, there's a Trustee Act which has like the types of powers that you could include, but there's not like a specific powers that you do. We have sort of standardized powers of trustees that we include in our wills. Different lawyers like to include different things, but
there's some sort of general idea so people aren't left out to figure it out on their own.
Yeah, there's not like a sort of standard, these are all the powers you should do. We like to be a little bit specific, but we also like to give the trustee a lot of flexibility in the wills that we prepare, because no one knows what's going to happen and what decisions they're going to need to make and in what climate they're making those decisions. That's the answer there.
Thanks.
So these are some other considerations. When you are making your will, we always, we're not tax advisors, we're legal advisors. So if you do have special tax considerations, speaking to an accountant is a good idea. And we work in connection with our clients' other advisors, their accountants, their financial advisors, if they have them, if they want input from them as well. You also need to think about where your assets are located. So if the assets are here in British Columbia, then obviously the will is able to deal with them, no problem. But if the assets are in another jurisdiction, say they're in an overseas jurisdiction, the will that we prepare is valid here. It may be valid in the other jurisdiction, but we'll always say, go get advice in that jurisdiction to make sure that this is going to work, because it may be that you need to do another will there or some additional estate planning there, so you can comply with the laws of where you are. The other thing is to consider the residency of the trustee. I touched on that earlier, just making sure that the trustee is located here in British Columbia, and that that's really for their benefit, and so they're able to administer the estate, they're able to come to your property, make sure everything's secure, and also if there are ongoing trusts in your will, the residency is really important of where they live, because where the trustee is usually where that trust is located for tax purposes. The other thing to consider is if you do have children from other relationships, and this comes up a lot with our estate litigators, is that there needs to be some sort of accommodation for those children within your estate plan, because even if you're, for example, in British Columbia, you can challenge a will if you're a spouse or a child of the person who's died. But if you leave everything and you have a legal obligation in your will to provide for your spouse and your children, so if you don't make a provision for your children from other relationships, they could challenge the will, and the will could be found, could be modified by the courts, it could be changed in a way that you don't necessarily want it to be changed. So taking all those issues at the outset and considering them and making provision for people is really, really important. And this comes up, I think I saw a lot of the questions before the seminar started were about online will kits and the advantages of those and the disadvantages. And one of the advantages of having a lawyer prepare your will is that there's drafting considerations and ensuring that the drafting meets what you actually want it to meet. So sometimes when you plug in information into an online will kit, it will come up with a perfect will that meets every intention that you have and that you can, and you're really happy with it. But it's also really important, particularly if you have some specifics that you want to include, to meet with the lawyer and make sure that it is properly drafted, that it does say what you think it says and intend it to say. I see I've got a message from Barry here. With registered investments that have beneficiaries, they don't need to go through probate. That's correct. So if there's a beneficiary on a registered account, that falls outside of the estate. So it doesn't go through the will and it doesn't need to go through probate. So that's an answer. Scott's got a question about ex-spouses that have joint custody of a dependent child. Would they have the right to challenge the will? And the dependent child has the right to challenge the will, but an ex-spouse does not. So we've touched on the use of a will kit a little bit, but a question I get a lot is where should you keep the will? You've got this document, it's really important. A couple of points are is that you should make sure that the will that your executor knows wherever you do decide to keep it, because they're going to need that original document at some point. Some clients like to keep them in home safes. Some clients like to get a safety deposit box at the local branch and keep it there. Wherever it is kept, you should consider filing a wills notice with the Department of Vital Statistics and if your will is prepared with a lawyer or notary, they would always be doing that. And that is a public notice that just says on this day, on this date, Nicola Collins executed a will and it's located at Scotia Bank on Main Street. So it doesn't say what the will actually says, it just says that there's been a will and that it's located here. I've even had clients say that they're going to keep the will in the freezer. So wherever you feel would be a safe place to keep it is probably fine, but make sure that the executor knows where it is or that they have a copy of it, and that's really important. And I have a question here about where you should register your will. That's the Department of Vital Statistics has a registration process where you can register it. Yeah. So another thing is, who should you talk to about your will? It's really up to you as the person making the will. A will is a private document. It doesn't become public until after you pass away. In saying that, you should let your executor know that it's in existence. You should let them know where it is. And I always advise, particularly if parents are not equal between their children, to have discussions with their beneficiaries before they pass away about why they've made decisions they've made in their estate planning, because that can be a source of contention, getting nasty surprises after the fact that can cause huge problems. So, I mean, anyone has the ability to revoke their will and make a new one right up until the very moment they die. So things can change, but if you are going to make a will that has some things that may upset some people, or decisions that may come as a surprise, then it's always a good idea, in my view, to have those discussions, or at least broach those topics while you're still around, because once you're not, it can be too late. And for clients that are not comfortable doing that, having discussions with beneficiaries, because you certainly do not have to, having a memorandum with your will, setting out the reasons as to why you've made the decisions you've made within that document, is always something that you can do as well. Just keep that with the document, so it can help people understand that. And obviously, if you have disabled beneficiaries, including a Henson Trust. So a Henson Trust is a trust that is an entirely discretionary trust, and that helps those beneficiaries keep their government entitlements while the trustee manages their inheritance and can distribute the inheritance to them on an as-needed basis in accordance with the legislation, so they don't exceed the amount that they're able to receive from there. And also considering charitable gifting. So charitable gifting is something that is really popular with my clients, particularly as a backup. If everything fails, if we're all not here and our nuclear family's not here, I want the rest of my estate to go to Spinal Cord Injury BC or whatever they want it to go to. That can have great tax advantages for the estate, but it's also something, if it's a small amount, doing lifetime gifting is also can be advantageous as well, so you get those benefits. Now Scott has a question here regarding executors, so making sure they can act jointly or independently in consultation with each other. That's definitely something that you should be including within the will. If you're having more than one executor acting at a time, then you should include a way in which they can make decisions if it's not going to be unanimous. So if you have one executor that you want to be able to override the other, then you should include that.
What's the benefit of having more than one executor?
The benefit is having a check and balance. Sometimes people will like to have a friend or family member as one executor and maybe a professional executor as the other executor. So the professional executor takes on all the administration of the estate and does all the heavy lifting, while the family friend doesn't necessarily need to do the heavy lifting, but can help make decisions based on the relationships with the parties. And a lot of people like to say if they've got 2 children, they'll appoint both as executors so that they both are stepping up and able to act together, because they don't want to offend one or the other. So they just appoint both. And so there's not necessarily a benefit to having 2, because it does mean that 2 need to make the decisions and step up and go through the probate process. And there's a lot of administration that needs to happen that both of them need to sign up on. But it's also a check and balance, making sure that everything's going the way it's meant to go. Yeah.
I think Susan had a question too, a bit of a unique one. If you have relinquished a child for adoption, but you reconnect with them, can that person challenge your will? What would those rights be?
No, they cannot challenge your will. Yeah. So once, if you have adopted a child, that child can challenge your will. But if you have relinquished a child and they're formally adopted by somebody else, then no, they don't have the right to challenge your will. But you can certainly provide for them if you wish to do so. You just don't have a legal obligation to do that. So just touching briefly, so I've got one slide saying probate and administration with 2 bullet points, but it's such a big process that I'm going to just run over it really briefly. So this process, probate, is when you take the will to the court, you ask them to approve that the executor is the proper person under the will, that the will is valid, and at the end of the day you get a grant of probate, and that's the document that the executor needs to take to third parties such as the bank, such as the Land Title Office and ICBC, and it proves that they have the authority to be dealing with the estate and the affairs of the estate. Now, a grant of letters of administration is when there is no will, and that's a process where somebody puts their hand up and they say, there's no will, I'm not appointed as an executor in a will, but we need to deal with this person's assets because there's people out there who need help right now with getting this done. And it's a similar process where there's a grant, letters of administration are eventually granted to whoever just wants to be the administrator, and then they use that as their authority to go and deal with the estate of the deceased person. So with both of them, there's a whole lot of different requirements. There's notices that go out to all the beneficiaries under the will. If you've ever been a beneficiary under a will here in British Columbia, you've probably received this legal document in the mail, and it's notified you that someone's applying for a grant of probate. If you also not only need to notify everyone in the will, but you need to notify everyone that was not in the will but would have inherited if that person had died without a will. So if there was a spouse that was left out or children that were left out, then or the next of kin, if there's no spouse and children, then they all need to be notified about the application for probate and or the application for administration. The timing can be a number of months. That notice, after that's sent out, the executor or the administrator has to wait 21 days before they can file the rest of the application with the court. So there's at least a 21-day delay. And there's a whole lot of information that does need to be filed with the court. And most of it is a listing of all the estate assets, the value of those assets as of the date of death. And eventually, before that grant is issued, there's probate fees paid on the value of those assets. And probate fees are approximately, on average, they're on a sliding scale, they're approximately 1.4% of the value. Yeah. Can you exclude anyone and thus prevent them from challenging the will? You can exclude anyone who is not a spouse or a child, because you can exclude them, but a spouse and a child have a legal right to challenge your will. So I think Tony will probably talk a little bit about that more, but that's a unique feature to the law here in British Columbia, that you do have a legal obligation to provide for your spouse and your children. And even if you do provide for them, but you provide for them not on an equitable basis, so you give it one child $1 and the other child the rest of your estate, then you can you can also, find them being challenged. And Tony's just made a comment here. Obviously, if there are other estate planning ways to sort of avoid these challenges, and one is to set up what's known as an alter ego trust, and that's if you're over 65, there's the ability to be transferring your estate out of your name into a trust, and therefore avoiding there being assets left in your estate to be challenged. So Lillian's question here about common law-like relationships. So if it's a common law relationship, you've lived together for 2 years, you meet the definition of a spouse, and that can also be a challenge. Yeah. And even there's been challenges, I think Krista, you can probably speak to that, where you've not necessarily lived together 2 years, but in the same place, but you're living apart, but you're together, and it's been a relationship for longer, met that 2-year minimum. So yes, they can challenge your will. And Susan's got a question, is there any way to avoid paying the probate fee? If the assets are in your name and they go through your estate, then probate fees are payable on them. The only ways to avoid that is by doing some estate planning, transferring assets into a trust, or transferring assets into other people's names. I have had clients who have been given terminal diagnosis and have decided to quickly put children on as joint tenants onto their property to try and avoid the probate fees at that time. So there are ways, with advance notice, there are ways to plan by giving away assets, obviously, but probate fees are payable before that grant is issued on anything that is left in your estate at the time you pass away. And Barry, just it's a sliding scale, the probate fees, but on average it's 1.4% of the value of the assets. Yeah. Oh, sorry, I didn't go over this. So these are a couple of ways to challenge a will if it hasn't been, so one of the ways in which it can be challenged is if the person making the will is found to not have capacity to make that will. So if at the time they executed that will, they didn't understand the document that they were making, they didn't understand that they were going to be disposing of the property that they had when they passed away, or if they had some sort of mental disorder which didn't allow them to comprehend what they were doing, then the will can be challenged. So that's something that as lawyers, we always meet with our clients, we ask them lots of questions, we try and make sure that they're really able to instruct us. And there's been times when we've had clients who said we can't take instructions, so we cannot the will that we cannot prepare a will because you don't understand what's going on. So that's one way that our litigators have they've been able to challenge a will, because if the will is found later, if it's found later that the person didn't have capacity, then that will can be found to be totally invalid, which if there isn't a will prior to that could mean that the estate is intestate. Another way to challenge a will is if there's a possibility that the person who made the will was under undue influence at the time that the will was made. So that's a situation where if somebody comes to my office and there's someone else with them who is very much interested in that person making a will and is pressuring them to do that and is pressuring them to leave everything to them, then that could be a situation of undue influence. So it's when the will maker is being coerced into making that document. And that can be challenged if later it's found that undue influence was there when that will was made, then that will can be challenged and be found to be invalid. We've touched on this quite a bit, but one thing that can also be challenged is if there's an unfair distribution of the assets between spouses and children. So this touches on a couple of the questions here regarding the common law relationship. So it includes marriage-like relationships for at least 2 years prior to that person's death. And children includes then natural born and adopted children. It does not include stepchildren or grandchildren. So that's something to consider. So Jolene, you have a question here. What can be done if a person dies and his closest relatives are not notified? It depends. The only time there's an obligation for people to be notified is if that person's estate is going to be going through probate or administration. And if you're the next of kin in terms of you're one of the people that is to be notified. So if there's a situation where somebody's passed away and the estate has gone through probate or administration without a child or a spouse, for example, being notified of that, then I do suggest that they seek legal advice, because they could definitely have a claim there. Scott asks, who determines what's fair? Well, what's fair is really what's fair to a child or to a spouse. If somebody is really upset with what they've been given under the will, then they may want to challenge it. And ultimately, it's up to the court to determine if that was fair or not. So this is another question here from Lynn. What if one of the children dies before you do? Can the assets still be distributed only to the remaining children? Or do the children of the dead child receive, or can they challenge the will? So grandchildren cannot challenge a will. So it's up to you as to how you want to manage that. If you want your grandchildren to inherit, you'll need to make a provision for them in the will. Most of the wills that are prepared will usually have a failure clause that if a child passes away with children, that it goes to their children. But that may not necessarily be the case. So it's always a good idea, if there are big life events, like somebody predeceasing you, to review your will and make sure that it is what you want it's saying what you would want it to say. And this, I think, is where, Tony, I'm pulling you in. This is your part of the presentation. So I'll just keep flicking the slides to you.
All right. So as Nicola mentioned, there are a number of ways that people can challenge wills in British Columbia, and this is a very specific one to BC, and that doesn't actually exist in many other jurisdictions in the world, and it's very important and something that we use in British Columbia in a sense to equalize what could be seen as an unfair distribution. So when there is good estate planning, in a sense, this usually doesn't occur, but in a lot of circumstances, when there is disinheritance of a child, spouses and children can make a claim for under the WESA. It's called the Wills, Estates and Succession Act, under a certain section, which allows for the court to step in and make a determination that they think is fair in the circumstances. Now, I know somebody commented and said, probably somewhat, I don't want to say sarcastically, but with a little bit of an edge, well, how can anyone decide what's fair? And that's a really good point, because a judge is a subjective person like anyone else. So it brings into a lot of risk and uncertainty into the situation. But really, when there is a legal challenge, what can happen is that the court steps in. So sorry, can you go back to the last slide there, Nicola? Basically, there are two types of obligations. So there's a legal obligation to provide for a spouse. And that's basically the same obligation that someone would have on a divorce. So the first thing that the court deals with is, if they have a spouse, what's fair to give to that spouse? And then the second is a moral obligation. So what would be morally right to give a spouse on death, in addition to the legal obligation? And if there are any children, what would their moral obligation be? And there's a number of factors that go into the moral obligation, and a very common theme in a lot of the cases we deal with on the litigation side is parents who disinherit children in favor of a second spouse. Now, when that happens, the children only are dealing with moral obligations, and the court has said that those obligations can be tenuous, but if the size of the estate allows it, their moral claim should be satisfied. So there are a bunch of different factors that go into these. It is rather complicated, But the moral of the story is, from the perspective of this presentation, if you have a good plan in place, this won't be necessary. So now we can go to the next one.
Just a question about that, Tony.
Yeah.
So that means that I guess I'm feeling a bit Hollywood right now in this question, but you know, someone can't give all their money to charity in their will and surprise their spouse when they pass away. That wouldn't be allowed.
So here's the distinction there. I mean, anyone can do what they want with their money. The legislation isn't saying that people can't do something. What it is it's a judicial safeguard to balance between testamentary autonomy and fairness. So somebody can leave all their money to charity, sure. But if they have a spouse and they have children, the spouse and the children can challenge, and ultimately the court will make a determination on what they think is fair.
I see. Thanks.
So the process of challenging, after the grant of probate, spouses or children have 180 days to file, and that it's filed by way of notice of civil claim in the court, and then from there it's just regular litigation. And some of the circumstances, which is in the slide here, is one of the ones I mentioned, where a child or a spouse is left out of the will. Happens most frequently in situations of multi-families, so a husband or wife has a second spouse. And it also happens when one child is favored over another or receives unequal shares. And a very common situation, like one of the people mentioned in the questions, is with property being transferred outside of the estate. Now that happens a lot, and the court can take that into consideration when looking at a wills variation claim. But importantly, that technically isn't part of the estate. So what we do as litigators sometimes is we file for a claim called a resulting trust claim. And again, I'm not going to go too deep into it, other than to say that if, from a planning perspective, if everything is detailed, the intentions of someone when transferring property before they pass away, there won't be a need for litigation, or else the litigation will be easily defended. But when property is transferred with no reasons, like a deed of gift or some sort of memorandum stating why the property was transferred, that makes it very easily attacked by a litigator. So there's a question here from Barry Arana. If you have a spouse, common law, no kids, can parents of the deceased person challenge the will? Short answer, on a wills variation basis, no. If the will states that everything goes to, let me just read that question again, sorry. Only the spouses or children to challenge. Now, that doesn't apply for causes of action such as ones that challenge the validity of the will. So if someone would be an intestate successor, they can challenge, like a nephew or a grandparent, and they would be entitled to something on an intestacy. They could still challenge on the basis of undue influence or lack of testamentary capacity, or that the will wasn't executed properly, because they are interested. They have an interest in the estate, because if the will is disproven, then they would benefit from it. So hopefully that answers the question. Now, another common issue we see that arises from poor planning is challenging of the executor position. So, not to say poor planning necessarily, but poor choice of executor, or an executor taking a position or taking actions that don't necessarily benefit the estate. And we deal with this a lot. Realistically, it's a simple application that can be done to court, but something that it is sometimes drawn out, becomes very expensive, and just wastes time and money unnecessarily. So if an executor for some reason doesn't follow the terms of a will, sorry, I'm just seeing these questions coming. If the executor doesn't follow the terms of the will, he or she can be removed, and they cannot use the assets for their own personal benefit. And there could be personal liability for the executor if they're caught breaching their fiduciary obligation to beneficiaries. Now, one of the questions I saw was whether executors can charge a fee, and yes, they can charge a fee, and the maximum fee is laid out in the Trustee Act, which is 5%, I believe.
Yeah, right. Yeah.
Yeah, but and that's up to 5%. Now, that's another issue within the realm of administration, because a lot of times, if not all the beneficiaries agree to allowing the executor to have that 5% fee, there needs to be what's called a passing of accounts. And that can become a litigated and complicated matter in and of itself. So again, choosing the right person to administer your estate, very important. And then from the other side, so you may be a beneficiary who wishes to defend the will because you're satisfied with the way it's written, and you think that even though it's unequal, it's fair. We defend wills on behalf of those people, and a common situation is when an executor is also the primary defendant, and that becomes, complicated at some points too. But there are usually reasons, maybe not expounded reasons in wills, but these all need to be borne out in litigation. Again, if your planning is good, if you have everything, if you've given your counsel the right information and everything makes sense, then there won't be any need for this. But there are ways that these issues can be dealt with, unfortunately, by way of litigation. But it again becomes very costly and time consuming. Can you please give me an example of why someone would defend a will? Well, a perfect example would be, let's say someone is a second spouse of a deceased person who has children from a prior marriage. Now their children haven't been in contact with their father or mother for 30 years, let's say, and now their father passes or mother passes away. They're entitled to the P1 notice stating that they can contest the will, and they choose to do that. Now the spouse who's been with this deceased person for 30 years is thinking, well, why should the child have a claim here? Because I have a legal claim that is more than the moral claim of any children. So that's a good example of why someone would defend a will. Sorry, no, I think that's probably it, Nicola.
No problem. I've got, there's another question here. If you have joint executors on your will and one predecesses you, does the surviving executor automatically take precedent without changing the will? So that's when it comes down to the drafting of your will to make sure that that is the case. Most wills will provide that the survivor of the two will be able to continue by themselves. So that's a good question. It's really important to make sure that the wills, it has some backups if these things do happen. And the other thing is from time to time, when we always say to our clients, every 2 to 3 years, set a reminder for yourself, bring out that will, have a look at it, make sure that it's still meeting, it's still what you want to happen. Because if it isn't, then you should look at changing it and updating it and revising it, because as life moves on, things change, assets fluctuate, they go up and down, beneficiaries come and go out of your life, executors come and go out of your life, and it may be that there needs to be an update and a revision. So if things happen and you to somebody that is mentioned in your will, it's always a good idea to bring it out and make sure that and take a look at it and make sure that it's still going to work for you. So moving forward here, there's a couple of other slides. I know we're getting close to the end of time. These are a couple of things that people have should consider when you're sitting down to make your will. There's all sorts of estate planning documents that you should look at getting in place. One being a power of attorney and another a representation agreement. So a power of attorney, it's a document where you're appointing someone during your lifetime to do anything that you can legally do by way of an attorney. You could prepare an enduring power of attorney, and that's a document that continues to be in effect if you become incapacitated. So if you're no longer able to make decisions, then that person can continue to act as your attorney when you are not able to do that. You need to ensure that it's properly drafted as well. Your attorney is someone that you should be trusting, like similar to an executor or a trustee of your estate, because they could definitely be misusing the power that you're giving to them under this document, and it can be revoked at any time. If you are capable of doing so, the document can be revoked, and you can appoint somebody else, or you can just not have one. So the issue that you may have if you don't have a power of attorney in place is that if something happened to you and no one was appointed as your power of attorney, and say you were in hospital and you were no longer capable of providing instructions to your bank to get money out of your bank account or to take actions like that, then the only other option that your family members or your caregivers would have would be for somebody to appoint, to apply to be your committee. So similar to a power of attorney, they can apply to be a committee of a person, which is making decisions regarding your medical care, your well-being, where you're living, who you're associating with, and committee of your estate, which is similar powers to a power of attorney. So being able to access bank accounts, being able to deal with your legal affairs, being able to transfer your real estate. So those are, it's a very involved application, a committee application. When I say involved, it's a lot more involved than having a power of attorney document. It does involve two physicians saying that you're no longer capable of managing yourself, managing your affairs. It can take time to get those assessments in place, and it's a court application. So the court could require some evidence, some additional evidence, and so on. So I have a couple of questions. Patty, I've got your question. I'll touch on that towards the end. But there's a question here regarding a power of attorney. Does it only apply to financial decisions, not health decisions? So a power of attorney on its own does only apply to financial affairs. You'll see in my next slide here, we've got a representation agreement. Now, this is commonly, in the past, it's a similar document to what was known as a living will. So a representation agreement that deals with your healthcare and your personal care decisions. It can, from time to time, include power of attorney language within the document, though we usually recommend that they are kept separated because you don't need to necessarily be showing both documents for all situations. They can include medical language within it regarding decisions about your what you want to happen if you were in a terminally ill situation, what kind of actions you'd want that representative to take, and a good reason why people would prepare these documents is it helps with family members making those decisions. It's there, it's in black and white, it's legally binding on them, and they need to follow your instructions. So it can help take away the stress and the anxiety of making tough decisions regarding your medical care if somebody needed to step in and do that. And we've got a question here regarding a basic fee to make a will. Basic fee can vary depending on the law firm. For us, it's for a couple, it's usually in the range of $1,200 to $1,500, depending on what instructions there are. Obviously, if it's an estate that's going to require multiple trusts, then the fee goes up because that involves additional time, and we do charge based on the time spent. But there are others out there that do wills at a lower rate as well. So it's really something that you should probably look around and see. There's a wide range of costs and level of service with different types of estate planners. So that would be something I would recommend doing. Now, Scott, you've got...
Sorry to interrupt. Can I just ask a question? Because I think that we've got people on sort of a whole range of economic ability to pay. So what, and I think, you know, people have talked about will kits. I know I've looked them up. Some people have mentioned notaries. What are your options outside of a lawyer, or also can you just draft it yourself and get a lawyer to sign it, or can you speak a little bit about that?
So a lawyer does not need to sign a will. A will is valid if it's been signed before 2 independent witnesses. Now, it is important that it's done correctly, because that's a way that a will can be challenged if it's found not to have been signed properly. So it's, you know, as a lawyer, I'm not going to say, you know, a will kit's going to suit everybody, because it may definitely not. A lot of what I do is looking at not just the document, but what's going through the document. What is the estate? What's going to work? So it's not when we say, you know, that's the cost of a will, that's not just me writing it, that's me meeting with you and going through your particular situation and what your wants are and what assets you have and how's this going to flow in this direction or that direction. So there's lawyers that prepare wills, there's notaries that prepare wills, and obviously there's will kits. So any one of those could be legally binding, but I can't say, you know, it needs to be looked at in terms of how it's executed. Is the person are they capable of making that will? Is it drafted properly? Because the less advice and the less, you know, instruction you get while doing the will, the more likely it is that you're going to have to go see Morgan or Krista or Tony, or your family may need to go see them to get some advice down the track. So it's yeah.
Okay, thanks.
So a representation agreement and power of attorney, I've got a question here, a fee for an individual. You know, it is similar, it might be a little bit less than what I quoted for an individual. We do charge for representation agreements and powers of attorney. We like to speak with clients if they're on those costs, but if, for example, a power of attorney is done at the same time as the will, we usually charge like an extra $200 for that document. Yeah. And a question from Patty, is a will kit valid of 2 signatures? That's if a will is executed, I mean, I don't know, I haven't actually seen a wills kit recently, or I know there's a wide variety out there. There are really strict instructions under the Wills, Estate, Succession Act, like how a will is meant to be executed. So it could be valid if it's being executed properly. I know that what's come up a lot recently with us and our clients during COVID is that our clients have had to execute wills away from the office. Now there's actually 2 ways of doing that remotely. One is that the client goes and gets 2 witnesses themselves and executes the will following our step-by-step instructions. And the other is that there's actually an emergency order in BC right now that if a lawyer is able to meet with their client and be one of the 2 witnesses through a remote execution, then the will would be valid under BC law, which up until now has been a big no-no. There's been no way that you've been able to execute a will over the internet in counterpart. But until that order expires, and at the moment that's up to Tuesday, and if it's extended, it will continue, but that is one situation where a lawyer does need to be the witness, but otherwise it needs to be 2 independent witnesses. Yeah. And that's all we had in terms of the presentation today. So yeah.
That's great. Thank you so much, Nicola, and thanks, Tony. I'm sure there'll be more questions, but I know that one question that came up that people submitted that they were wondering about how to make your will or how to reduce the burden of tax on beneficiaries. Is that something you guys are able, I know it's probably complicated, but is that something that you guys would help your client with, or would that be a financial planner, or what are your thoughts?
It depends. Are you talking about like the probate tax or the...
I guess we don't even know what we're asking. I think what is generally understood is that when somebody inherits money from somebody, that they're going to have to pay some sort of tax on it, or there's going to be a cost to the beneficiary.
So there's not if you receive an inheritance, there's not actually income tax payable on that inheritance. But there's all sorts of tax planning that can go in and that can go on within a state. So depending on what the assets are, you know, at the point someone passes away, they're disposing of their assets, there may be a capital disposition, and then it goes into the estate. So my advice is always obviously to speak with an accountant as a first step to get some specifics about each situation, if you're concerned about the tax consequence. Yeah, but in order for a beneficiary, if you receive a $100,000 inheritance, that's not considered income. Yeah.
Okay, thanks for that. And I think there was one more question.
There's a question here saying, are there any issues with an executor being a beneficiary? No. Not on the face of it. It really depends on the relationship and if there's other beneficiaries there. But an executor could be the beneficiary. There's nothing that would prohibit you from doing that. There's, you know, if you had one child as the executor and all of them as beneficiaries, then it could cause some friction. But it's very common that clients will have a child as an executor and be inheriting under the will as well. Yeah, so the question here is, if you have property in Alberta, do you need to write a separate will for that property, or will the British Columbia will cover that? In most instances, the British Columbia will be adequate, but depending on what that property is, if it is real estate, you may need to get that grant of probate resealed in Alberta in order to deal with that. And that's the same here. So if somebody from another province, so somebody from Alberta passed away and they had British Columbia property, then the grant of probate that they get in Alberta needs to be resealed here in British Columbia in order for them to deal with that property. Yeah.
I have a question actually, Nicola, if that's all right. So my question, someone had told me at one point in time that it was a good idea to have your executor of the will sort of not related to you. It's kind of someone who's maybe a little bit more distant, that doesn't have the same investment, I guess, in the will. Is that?
I mean, it really depends on your situation and your circumstance. If you are having a will that's going to have ongoing trust for a number of years, for minor children, for example, having someone who's not related to you, that's a little bit a step back, may be a good idea, because then they're not so, you know, emotionally connected to the children. I mean, obviously you want someone who's going to care for your family and be able to be there, but they may be able to make impartial and objective decisions regarding your estate. But certainly a lot of people will appoint close family members or close friends. It doesn't have to be somebody that's not related to you at all. They just need to be someone that is capable of making those decisions and capable of managing your estate and your affairs. Yeah.
And do you have like I remember when my father died, I wasn't prepared. So emotionally, probably I'm really glad I was not the executor of his will, because emotionally having to deal with the death of, a sudden loss sort of affected me differently. So do you sort of have a discussion with the executors on what this, means, and, how, if you are emotionally prepared to be able to take that on? Because I think it would be a large.
So one of the, when I'm dealing with clients in probate matters and an executor comes to us and says that they've been appointed in the will, before they start making decisions about the estate and about what needs to happen, before they start intermeddling with the estate, that's always something they need to consider is, do they want to take it on? Because you're entirely right, Terry, it's a huge job. It can be, depending on what assets that person has, if they've got a business, if they've got assets in various jurisdictions, it can be a really, really, really stressful and time-consuming administrative task dealing with somebody's estate. So it's something that clients, some clients will say, look, I don't want my family to be doing that at all, because it's not something that I want to put on them. So they will appoint a trust company. Now, I see there's a question here from Susan, and the names of some trust companies that can act as an executor. I do encourage you to do your own research on that. There are, most of the large banks have a trust company portion of the bank, so they will step in and act as a trustee. There are a couple of independent trust companies out there, like Solus Trust and so on. So yeah, there are some out there, and you really want to make sure that you're comfortable with them. They obviously all charge fees, and they all, I'm sure they would do a good job, but they do this as professionals. And I've got a question here saying, if you have a will and it states a caretaker for your children who are minors in the event that you die, and your children are now of adult age, do you need to update your will, or is that mute when your children become adult age? That would be mute. If your children are now, they've now aged out of that, you don't necessarily need to update your will just for that reason. And there's a question here from Lillian. If we change our mind about being executor and we can no longer contact that person to tell them, what can we do? So if you've been asked to be an executor, somebody else has prepared that will, at some point you may be contacted when that person passes away by somebody, and they may be asking you to act as an executor. So that at that point you're saying that you're going to renounce. You need to renounce it at that time. You can't force them to update their will, but if you are ever contacted, you would need to renounce. I had a question back here that I had from Christina. Can you make a will for your parent who isn't capable, and how would you go about that? Unfortunately, that's not something. You cannot make a will for someone else. If your parent is no longer capable, then they would not be able to make a will. So that's one of the requirements. So yeah, that's something that unfortunately, if they are not able to provide instructions and to understand what they're doing, then they cannot. That will could be, any will that they made could be found to be invalid if they were not capable.
I have a question, Nicola, that somebody sent to me privately.
Mm-hmm.
Okay, so the scenario is you have grown children, you've remarried, but the majority of your estate was money that you made before your marriage, your new marriage. What are your obligations to your current spouse?
Yeah, your obligations are still that you need to provide for them. That would be something that would be quite specific to that person. So I would, similar to, as Tony mentioned before, similar to if there was a marriage breakdown, could be a starting guideline. But yeah, having some advice, both from an estate perspective and a family law perspective, would be recommended. Yeah.
Thanks.
A neighbour produced a vine. I see, yeah, Morgan's already answered that online there. And Tony's very loyally answered, it depends. And Susan's asked, how do you prenuptial arrangements factor with regard to wills? So that's a question that I'll always ask every client. Have you got a prenuptial agreement? Is there a marriage agreement that I need to know about? Because from time to time, those agreements you'll address in our estate, we are going to be doing this. And that's something that we'd take into consideration when preparing the will to make sure it's in line with that agreement. Yeah.
You probably mentioned this earlier and maybe I missed it, but what is a good, or is it age that you should determine a will? Assets, like at what point in stage in your life would you start thinking about having a will?
It's, most, I would say, as you should have a will from when you're of the age of majority onwards. Like you should have one in place. But in saying that, most clients come to me at the point they have children, because that's when they realize that if they don't make provisions for their children, then they're concerned about that. But a lot of people do not have wills in place. And what that means is that the law, the legislation is going to say what happens to those people, to their estate. And it may be that if you don't have a will, that your assets are held jointly with someone else. A lot of spouses have all their assets held jointly, so it may be that you don't actually have all that much that's going to go into your estate. But it's a document that you should have in place. You should get it there. You should do it. No one likes to do it. I have clients who come in and they give me instructions. I prepare their wills, and they go away and they take months and months and months and months to actually sign it, because it's one of those documents that just makes people feel sick about getting it done and getting it off their plate. They don't want to think about it. They don't want to have it. It's kind of a death and taxes. It's a certainty, but if you don't have it in place, it's not going to be there. And we have clients who haven't had them, and it's caused ginormous issues. And clients with a huge amount of assets that you would think at your stage of life and your complicated situation, you should have thought about this at some point, and they haven't. So even if you don't have a lot of assets, you still have a family probably, and they probably are still going to want to know what you want to happen. And a will can, as I said, a will can also say what you want to happen with you, with your body, with are you wanting to be buried? Are you wanting to be placed here? Those are things that you can put in there that can be useful for people when they're trying to decide things after you pass away as to what your wishes were. So, yeah.
Thank you. Bert has a question. So, Bert, you're on.
Oh, the question I had, it was about the Henson Trust. Do you set those up before, like before you pass?
Yeah, so what I was talking about is in an estate, in a will testamentary context. So we can put those terms within a will to provide for the disabled child or the disabled beneficiary, and it only comes into effect at a trust that's within a will is known as a testamentary trust. It only comes into effect at the time that somebody passes away and the estate's wound up and the assets are put into that trust.
It's the reason I was asking was, and it accounts for adult children, like the child has autism, he's 60 years old or 50 years old, he's on PWD. So would you set that up ahead of time for him?
You can certainly, yeah, you can certainly you can do that as a trust that you set up during your lifetime that's not in the will, that's separate, or you could set it up in the will so it comes into effect at the point you pass away, that their inheritance goes into that discretionary trust, and there's a trustee that manages that trust during that person's lifetime. Yeah.
Okay, thanks.
You should be able to unmute yourself.
There's a question here from Susan that says, do you have or provide for clients a template that is online to assist them in writing their will? No, we don't have an online template at the moment. If clients are looking, sometimes what we'll do is we will send them a questionnaire in advance of meeting with them to gather information. But yeah, no, we don't have an online wills template at the moment.
Okay. I had another question. It's Susan here. And my parents, when they died in Alberta, I'm just wondering about that Henson thing. When they died, I had this disability. I fractured my spine back in the 70s. I had to sign something to say I wasn't prepared to, I was able enough and didn't require more income from the will. Is that what the Henson Trust is?
So a Henson Trust is a discretionary trust, and what that means is that that beneficiary's assets are put into a separate pot and they're managed by a trustee, and that trustee will only release them to the beneficiary at their discretion. So the trustee can work with the beneficiary to ensure that it doesn't exceed the guidelines for the amount of inheritance or income or assets that that beneficiary has, so they can continue to receive their government benefits.
Question probably is, can you put that that you request, if necessarily, that you have a medically assisted death within your representation agreement?
You can put in language to that effect, and yeah, you can put your wishes in there. Yeah.
And then Scott, you're up, Scott.
The Hanson Trust, does it have to be I don't know how to say that, an official trustee, or can it be a family member that administers it?
Yeah, of course.
Understanding.
Yeah,
Okay.
it can be.
Do they have to be named in the will when you're
Yeah.
naming it? Hanson? Okay.
Yeah.
Thank you.
Well, I just want to let you guys know that in addition to the recording, the folks at Hammerberg Lawyers have agreed to put together a handy blog post for us. So that will be available on our website sometime soon. So keep your eyes peeled for that. And I guess I'll just say thank you guys so much. This was so informative. I know that there's so many questions that people have, and also that everyone has an individual circumstance and individual things to consider. So it is hard to talk in broad strokes. But thank you guys for answering everybody's questions. And also I want to mention to everybody on the line here that Hammerberg Lawyers is not only providing this webinar for us, they're also a program sponsor for Spinal Cord Injury BC. So all those awesome programs that we do throughout the year, and certainly through this COVID time, all of the Zoom programming that we've been doing is in large part thanks to the generous support of the folks at Hammerberg Lawyers. So just want to say thank you guys so much for your support, and looking forward to doing more things like this in the future.